Hey guys, what's up? Welcome to episode 5 of Startups. I have my co-host Dan with me here, and we are joined today by internet lawyer specialist Leonard French. How are you doing today, Leonard?
Good. Hi, how are you?
I'm doing
Glad to be
great.
here.
A lot of people in my chat are already familiar with you because we've actually listened to some of your videos in whatever copyright safe way is permissible while streaming about your.
All right.
Yeah,
You don't have a lot to fear from me.
okay. You've covered a lot of like internet drama relating to stuff that we've gone through. I don't think it was related to me specifically, but stuff related to doxing with a content creator. I don't even remember which one it was. And then going over the Maddox and Dick Masterson case a little bit, that
Oh, yeah,
harassment suit
I
that was filed.
remember that one. That
Yeah.
was fun.
Yeah, so we've had a little bit of overlap in terms of content. But
I
yeah, do you
figured
want
we
to?
would update on that. Yeah, I don't remember what the update is on Maddox versus Masterson, but that was a fun story to do.
Yeah. Oh, and then the stuff related to we call him JF. It's like Jean-François Gariepi or whatever. I don't know how to pronounce his name.
Jean-Francois.
Yeah, something like
Oh,
that.
it
Yeah.
just doesn't ring a bell. We've covered so many stories. I have to admit, sometimes I even forget what stories we covered, like the same day that we did them.
Yeah, that's fine. But for people that don't know you in chat, do you want to introduce yourself?
Sure. I'm Leonard French. I am a 39-year-old copyright attorney from Pennsylvania. I've been practicing law for almost 8 years, so 7.5 years now. In a former life, I wanted to be an electrical engineer, and the math made it a little bit hard, so I ended up with an IT degree, and then the IT degree only got me so far, and I got interested in the law for various reasons that I don't know, maybe we'll go over today, and took the LSATs. My scores were good enough to get into a local law school, and I decided I wanted to pursue something that had more opportunity than my IT degree was at the time. Now, I still think that my IT degree has some merit, and electrical engineering is a great field and all that, but
Hmm.
I ended up in law. That's more or less the short version.
Is that I have no idea. In law school, is it pretty unconventional that people you need like don't you need like an undergrad or something before you attend law school? Like you need an undergrad in something?
Yeah, I believe you need at least a 4-year undergrad, and no master's degree is required. Um, but
And
I
it's
think
4 years of law school, right?
for an ABA accredited law school, you need at least 4-year undergrad, and it's 3 years of like full-time day law school. I ended up doing a night program while working during the day, so mine was a 4.5 year if you count the summer semester that I took.
Interesting.
What did
The
you when you originally went to law school, what did you want to do? Like did you have like a dream like type of litigation that you wanted to be involved in or
I wanted to escape the hell that I was in with my former employer. I was highly motivated to get out of whatever was happening to me then and get into something else. I was having a sort of legal issue with my former employer, and that got me, plus some other life circumstances. My roommate at the time had gotten a ticket out of state, and so I had to drive him to Ocean City, Maryland to sit for his traffic hearing, and it was one of those all calls. And so I'm sitting there in the gallery, and everything's proceeding in a very orderly fashion. I was very impressed with the Ocean City court, and that also interested me in the law, and I wanted to explore, what's it like to be a lawyer, and uh, could I be a lawyer? It was kind of a pipe dream at the time.
so what age did you start the whole lawyer dream? 31?
20, oh, so yeah, 31 would be when I got my law license, and then I started law school in 2007. So I would have been 27.
Interesting. And the law school that you went to, is that one we've heard of? Is that make a big difference when you're going and you're getting these types of jobs going after that? Like, were you really
It,
selective
it,
of
it,
what law
it
school you're going to?
there's one major giant like threshold. If you're looking to get into big law, which is usually considered about the top 10% of law students, then you need to be the top 10% of law students to get into these larger law firms. Uh, I don't know all the names off the top of my head, but Sullivan and Cromwell was one that I worked with for one case. Um,
when you say top 10
and
students, do you mean like you're going to like
top
a
10%.
top like a does that mean you're like top of your class or you're going to like a good school?
Like a
Mostly
Harvard?
top of your class, and yes, top tier law schools. So the best law schools and the best in your class have the best chances of getting into what we call the big law firms. So I went to a fourth tier law school as rated by, what is it, U.S. News and World Reports or something like that. And that sort of law school doesn't have the same chances of me getting into a big law firm, big law with capital letters, than say Harvard or Yale or Georgetown or another Ivy League school or other heavily recognized top tier school. But that doesn't mean that a top student from Widener University couldn't get into a big law firm, but it's going to be less and less of those top students as you
I
get
assume
further.
it's very much
Other than
like
that,
it's better to be the worst performing student at Harvard than the best performing student at Michael Cohen's school, then, or no?
yeah, maybe it depends on if you're looking for that big law experience. Not everyone's looking for that to get into big law, and if you're not looking to get into big law, like I wasn't, then you don't have to shoot for that, and you can pass the bar by 1 point. You can pass school by with a 2.0, and you can still be a lawyer.
Do you know how important is it actually when you're going? Let's say you are going to try and do the Suits lifestyle. If you've seen that television show,
I am
but
not actually.
oh, okay,
Sorry.
that's a very like
I
I
avoid
think that's
law
what you
dramas mostly.
I think that's what you would call the big law type of job, like corporate life, litigating mergers and acquisitions and all that type of stuff. But
Sure.
if you're going to these things, what you're saying is actually like grades are significantly important. It's not just if you're summa cum laude or something like that. It's like they're actually looking at your transcripts and seeing how
You
you
know,
did if you want these bigger jobs.
I don't know. I really don't know the application process for that. But yeah, that would be where they'd be weeding people out, looking for the best of the best. And yes, there probably could be some strict selection criteria. There could be even some arbitrary selection criteria. Um, so yeah, if you're looking for that specific kind of job, yeah. Other than that, I have never heard of any of me or my colleagues, anyone ever asking to see what we studied in law school, hear about our grades or anything. Maybe talk about our experience,
Sure,
um,
sure.
but
So
generally speaking, there's no further barriers that I found.
so tell me about your early process then. So you just got your law degree. Where are you going from here? What is the journey that takes you to being the most well-known attorney on
Oh,
YouTube at this point?
well, besides immediately finding myself with a case of imposter syndrome, feeling totally like a fish out of water, not really being prepared for the business of law, and sort of just trying to figure out, okay, well, we got our law license, now what do we do? I sort of had planned only so much. I had some things happen. Like I said, my relationship with my former employer fell apart. I wasn't planning to work for them as an attorney, but I also we didn't exactly have a healthy
Well,
separation either.
I don't mean to ask too much, but like what was the disconnect that you had? So out of law school, you went to work for another firm, correct? Is that
No, no, no. So I was already working for a local electronics company,
okay?
and I have a non-disparagement clause with this local company, which is why I'm not mentioning their name and not going to be saying anything terribly negative about them.
Sure.
But we basically had a disagreement over how much work I was doing and how much I was being recognized for that work. I had been promoted, in my words, I had been promoted several times, but I had never been recognized for the new positions and the new responsibilities. And I was looking for just a modest pay increase, and we
Oh,
ended up
that's the classic
separating over
strategy
that.
for keeping someone around without giving them an increase. Like, congratulations, you're now the assistant to the regional manager. Do I get more pay?
Yeah.
No, no, but like this looks fantastic on your business
I
card.
went from general technical support to special technical support, which was a paid promotion, but then to IT, then to engineering process improvement, then to engineering support in-house, then to engineering field support, and even to the point that I was making my own software and making my own hardware products. Nothing remarkable. I mean, just very basic entry level development and stuff. But they were definitely very helpful products for the company, and I was saving the company a rather large amount of time. There was no reason why they couldn't give me a modest increase, and I really wasn't looking for much. But it wasn't the amount that we never even got to an amount. We ended up separating on just whether I deserved it at all.
If you have a
Interesting.
disparagement clause and you specifically say you can't say anything about this company because of that disparagement clause, can that be considered disparagement?
No, I can't disparage the company. I can't intentionally act to paint the company in a bad
Yeah, I
light
know, but by saying
and
that you can't talk
cause.
about
I
them,
actually have to cause damages too. I can't
sure.
just
But by
not
saying that you
just talk.
can't talk about them because by talking about them too much, you would necessarily disparage them. Isn't that kind of
We're
disparaging?
we're getting into the warrant canary stuff. Oh, if
It
you can
could
No,
have a
be.
I'm
disclaimer.
just messing with
It
you.
could be, and if they really wanted to try to test this, sure, we can have it out. But
Sure.
I don't think that either of us are interested in furthering our relationship
Is
anymore.
that
Is there no time limit on those statute of limitations on this at this point? Is it
That's
just
the other thing. 'Cause it's been like 8 years. There should be something, right?
mhm.
It's been 9 years actually.
is
There
that
should be
yeah?
some
is
kind of
that one of those
limit.
clauses that like isn't like enforced everywhere, kind of like the non-compete clauses, or is that something that's like generally
You
universally
know, I don't actually know. As much as I'm an attorney, I don't interact with non-disparagement clauses at all, except for my own that one time.
hmm
So,
Gotcha.
and
Aren't
that
you
was
never
actually this
supposed
is the
to be your own
subject.
client? That's
I
the
don't know.
first rule of law school: is
I don't know
lawyer
if
as his own
you.
client.
Well, I don't know if you saw on Friday we released a video where I told a whole story about hiring an employment attorney who then didn't really do much of his job, and I didn't really get much out of my employment separation or my relationship with my attorney. And then it turns out that he was neglecting many, many client matters to the tune of millions of dollars, and they just suspended him for 5 years, which is the maximum he could be suspended without being disbarred. So we went over that whole story, very fresh in my mind.
Damn. So, do you have like what is your like position right now legally? Do you work for a law firm or do you have like your own small kind of company or?
I am a sole practitioner. I
Mhm.
have my own law firm, which is just me and an assistant, and some contractors that help me with development and things, help you with maintain a website and maintain the Discord channel.
Are you actually involved in like actively like litigating things, or do you just maintain your being a law firm because it gives you some other benefit to talk about legal stuff, like access to Pacer or something? Or
I am actively involved in litigation, but at a very light level. So we have a Rule 1.1 duty of competency, which means that I can't take on more cases than I can handle.
Mhm.
And so I have literally one. Well, it's hard to say because some cases are sort of in pre-litigation. These cases that I do are BitTorrent piracy cases. The defendants are being notified about a case before they've been served with a case. So are we litigating yet? If we haven't been served and we're just talking about settling a case outside of court, that's mostly what I do is settling cases outside of court. But then yes, I wouldn't have my teeth as a settlement negotiator if I didn't also prepare to defend my clients in court.
So these are the notices that a lot of cable providers will get, where it's saying you downloaded. We noticed your IP downloaded Forza 4 or whatever, and as a
Yeah.
result, we have a settlement option. I thought that there was actually a recent case law that said that had to basically be cut down more, and that IPs were not actually identifying pieces of content. Like, wasn't there an entire industry that was shut down from that type of predatory practice?
There are entire courts that have blocked that kind of practice. And what you've talked about is very, very similar to what I do, but actually just one hair's breadth away from what I do. The practice that I defend defendants against is an actual lawsuit gets filed and a subpoena gets sent, as opposed to like a DMCA takedown notice that then also contains a settlement notice inside of it. We call it a DMCA settlement notice. It doesn't actually exist within the law. There's no legal anything to do with putting a settlement notice inside a DMCA takedown. So who knows whether the ISP has to forward that on or what. And I believe Canada recently shut that entire practice down.
that
I don't
sounds
know
Yeah,
about I don't
awesome.
know about the
So
US.
a DMCA take. So you're saying that I could send a DMCA to YouTube, and within the contents of the DMCA, I literally say you have to pay me some money, or what? I'm gonna try to sue the
To
person
the
host
user.
to the user.
Yeah, so if you would send a takedown, YouTube is just hosting the user's content,
hmm
and you would include a settlement offer to the user inside the takedown to YouTube, and then YouTube is supposed to send your takedown notice on to the user as part of the notice, and so they'd also receive your settlement offer. Some ISPs refused. They would literally edit that part out of the subpoena takedown, or not subpoena, the takedown notice, and then forward on the actual takedown part of the takedown notice, and not forward the settlement offer on. But then what if you're a guilty party and you later on get sued? Did they just foreclose your ability to settle for $200 instead of $2,000? So
Well,
now
I mean, I would
nobody can
imagine
do
that
it.
like if somebody is offering, I say this, I mean, you would know better than me, but I would imagine that like for some of these ISPs, if they're offering a settlement for $200, they're probably not going to forego that settlement and go hardcore into like litigation because you didn't accept the initial, right? Is that really worthwhile?
That's the threat. That's the threat, though.
Mhm.
And some of these companies have thought about that. I don't remember if it's actually gone any place, but there was a company a few years ago. I forget if it was a Leibowitz or C. There was an attorney who was filing exactly that, and you would go to his webs. He would have a website all set up with a login, which was just simply a long, unique identifier split into a username and password,
Mhm.
and you type that in, and then he would present you a settlement offer, and I have not seen those in a while, so I'm assuming that that ended because it wasn't profitable. But yeah, that's the threat, is that if somebody doesn't pay up at that sort of initial level, which I would start calling a scam or extortion or something. But in all honesty, I could probably get in trouble if I get too specific with that, because that's probably defamation on some level, because it's not actually a scam and it's not actually
Well,
extortion.
we're not actually
It's
saying anyone
there's
specifically,
a
right?
legal. Oh yeah, I'm not concerned. I just mean that it's not actually extortion under the law. We're calling certain copyright trolls could be defamation because they might not actually be copyright trolls. They might be legal copyright plaintiffs who just act very trollish.
So, okay, take us through. You've just left your job here. What does the beginning steps of your firm look like, and how do you get to that point? Doing that, and what's going through your mind as saying, I'm not going to go work for another firm, but I'm going to start up the Leonard French Institute for Fine Legal Scholars.
I wasn't doing so well at the end of law school. I had a fiance, and my fiance left, and that was right before the bar exam. And so, coming off of the bar exam, I sort of just assumed that I had failed. I assumed that I sort of, I don't know if plunged myself or I was plunged into a Great Depression, and so coming off of that, I sort of almost had very little hopes for myself, and I was just surprised when I found out that I had passed the bar exam, and that helped my mood a little bit. And a lot of that was situational. And as I got over the relationship and got past all of that, the taking the bar exam itself is also a traumatic experience for most people. So as I came off of all of that, I started to ease into, okay, well, I've got to do something now. I was excited to have my license. I got my license. I even paid to have it. Like I forget if I paid or not. I would overnight it or something. So I called on the day so I could get my license the very first day you can get it. Like you find out you get your bar exam results, then you have to file one more set of paperwork, and then like you're not allowed to call for like 2 days or something. And I remember I called like as soon as you're allowed to get my day as soon as possible. And then it's like, okay, well, you've got it. Well, who's the heck is going to hire a brand new attorney who has no name recognition, no business, no insurance, no anything? And so then I remember by about November 5th, which was so it was October 20th, by around about October November 5th, 2011, I had finally made my initial version of my website. I had been studying Ruby on Rails, of all things, and I spent a couple days building my whole website out of Ruby on Rails and trying to avoid using JavaScript as much as possible, and being very proud of myself when I got it all done and everything, and still wondering, what am I going to do from here? And I had a family friend who reached out. She's a family law attorney, or was a family law attorney in Bethlehem, Pennsylvania. And this was about January 2012. And she offered to mentor me. I could come to her law office and see how a real law office works, shadow her to court, and everything. Well, she got her fourth and fifth back to back driving under the influence charges
Jesus.
pretty much right away. So this example I was getting wasn't very helpful. At least I did get some insight into the local court system in one county over. But I really wanted to do copyright law. But like I said, how I'm kind of a fish out of water, green in the pasture. Really, what am I going to do? What are my prospects? I don't know anybody. My family doesn't come from attorneys. Um, like I said, I wasn't exactly doing so well. It's not exactly like that doesn't show through. So who was going to hire me? So my whole thing was I was just going to go for it because what else are you going to do? Oh, also, let's remember this is right after the 2008 crash. We were still in the throes of not recovering from the 2008 market crash. And that hit the legal industry very hard. Um, People, for some reason, woke up. I don't know why they didn't wake up before. I really don't understand people sometimes. I'm feel like I live in a different world once in a while. But
I know
people
how you feel, Leonard.
finally woke up and were like, oh, we're paying way too many billable hours to our attorneys. We should stop doing this. And the world just like collectively stopped paying their attorneys for a few years. And that's, I came directly after that. But so the practice had pretty much the time you got concerned about attorney overbilling or even just normal billing practices are now scoffed at. I try to quote people prices that are just totally normal for a case, and it's the end of the world. I don't mean anything against my clients. It seems to be everybody is having this reaction to legal fees or such. People don't necessarily want to go to court, don't want to pay their attorney as or rather want to pay their attorney as little as possible.
Mm-hmm.
Only once in a while do I find somebody who understands why you want certain professionals or really any worker to be appropriately paid in order to be, not only properly motivated, but you don't want them to be demotivated by being distracted by having to do other work or, figure out how they're going to live when you only paid them a half rate or something like that.
Mm-hmm.
I digress.
This is like very loosely related to this, but I remember I worked in the casino industry at around the time when all the markets crashed, and it was very interesting to me. It feels like a lot of the benefits and everything like went away for a lot of the lower level jobs. Like a lot of the 401k matches went away, a lot of the yearly raises went away, a lot of the employee of the month $500 bonuses, all of those things seemed to disappear. But then when everything recovered and all the markets were on the up again, I feel like none of it ever came back.
Yeah.
That was like a very weird feeling. I was like, well, hold on, wait a second. Like the markets have fully recovered several years later. I was into streaming at that point, but talking to a lot of people that still work those jobs, because I would kind of like poke them, like, did they ever bring back like the vacation time or the 401k matches? But like, no, a lot of it like never really came back, even though everything recovered. And that was kind of okay. That seemed a little shitty.
It's hard to kind of feel out how much people are getting those benefits or not. But yeah, it definitely feels like in every company that I've touched and every friend I've talked to, that a lot of that was cut back. And I haven't been anywhere near corporate America for the past few years, so I don't know if it's coming back. I don't feel like it's coming back. But
well, yeah, I mean, if you've gotten away with not doing it, I feel this has got to be like a management strategy. Like if you can make a cut to some budget and your thing still operates. I noticed that this, I'm just not trying not to sidetrack too much, but I noticed this a lot from like a supervisory position in a restaurant, that like every now and then you'll lose an employee and you'll be running a shift like with less workers, and it seems like people are surviving, and as long as you can like survive, that will carry on like indefinitely. So it seems like if people feel like they can make a cut in the budget somewhere and things don't absolutely fall apart, that they will like bare staff you or pay the minimum they possibly can just to keep things working. Yeah.
Yep.
What
So your first case was the DWI, correct?
No, that was actually she handled that. I forget how she handled that. I think it was on her own or with her attorney. She ended up getting 2.5 years in state prison or county prison
for a second DUI.
For fourth and her fifth.
For her fourth, those two were her.
So it was two, but it was her fourth and her fifth lifetime, and or whatever it is within 10 years or something. No, I think it was lifetime, and they counted them as 2 third offenses, which is 2 minimums of 1 to 2 years or something, and I think she got 2.5.
Mm-hmm.
So were you prepared to try and intervene in that case and act as a lawyer?
No, and the story. So what ended up happening was she didn't think she was going to be sentenced to jail time. So she did not shut down her law practice until after she was given 2 weeks to report to jail. and then served 2.5 years. So she handed me the remainder of her practice, which would normally sound like an okay thing, but there wasn't really much left to the practice. It was a building and a bunch of angry clients, maybe a dozen angry clients.
Thanks.
And so I learned a lot. I learned an awful lot about the practice of law from my mentor in that sense. Ended up being able to successfully shut down or transfer or finish all of the family law litigation that she had going on. And because her practice and she personally, and I don't think that's unfair to say, was deteriorating at the time. I believe she's doing better now. I have not in contact with her. But because she was deteriorating, her clients had left, and the clients who have the ability to leave first. So we're not talking about the best cases we're sticking behind. We're talking about the worst cases we're sticking behind.
The ones
So,
where nowhere to go. Yeah.
Nobody do this. This is a cautionary tale. If this is your scenario out of law school, do not do this. This was not fun, and I could have gotten in a rather large amount of trouble if I had screwed up any of these matters, well, at all, pretty much.
Well, it's interesting because you basically jumped in head first into this type of stuff. Like, to me, it's like, if you just get your medical degree, like, you're not going and doing surgery the next day. Like, you're literally out there, like, I don't want to say litigating stuff, but like, you're taking real cases.
Well,
you're not like the assistant to another attorney.
It would be akin to that to a doctor then advertising, hey, I've just got my medical degree, I can go do your brain surgery. I'm supposed to have a rule that says I don't do that because I know better. I know that I can't handle that. So in that sense, you can read about Roskowski versus the internet was a attorney who took a capital murder case right out of law school or without any trial experience and screwed it up royally. It had mistrial and everything. And then the internet, of course, wrote about the rantings and ravings of the attorney, and then the attorney sued everybody. And I believe one of the only companies or only entities that paid out was his law school. I guess they were pretty embarrassed. But everybody else fought him to the ends of the earth and won.
So, okay, so you've taken over this practice. How soon after that do you realize that copyright law is your calling, and that is going to be your, the thing you're hanging your hat on, and you're going to go hard into this, and this is what gets you, most.
Pretty quickly, when I set up my initial website, I had made a page about how I would be willing to represent people with copyright problems or copyright cases. So first of all, one problem, I'm in Pennsylvania. Pennsylvania is not a copyright haven. You don't see people litigating copyrights in Pennsylvania much at all. Maybe the occasional music copyright case where some bar doesn't pay their licensing fee and UMG or some other rights group comes along and sues the bar for not paying their bill, and they have to get a license. That's about it. However, copyright called me, and I'm not saying in like the toot my own horn sense. I mean like this was just by total coincidence. I started my career at the beginning of the BitTorrent file sharing phenomena, which has been going on for the past, well, I guess 7 years, where civil litigants, not from the music industry, not from major motion pictures, but from adult entertainment, have started to sue using previous case law from the Napster, then Kazaa, and some other initial BitTorrent cases. What was it? Expendables was one of them. Those were older cases that didn't go anyplace because it's really, really bad press to sue your customers. HBO doesn't sue people over Game of Thrones, but adult entertainment companies like Tushy, Raw, Black, and Vixen, or actually Raw is one of their sub-brands, so it's Tushy, Black, and Vixen, and then XArt, they all sue I don't know if you call them, it depends on which side of this you're on. If you're on the copyright defense side, they're customers. If you're on the plaintiff side, they're thieves. Mm-hmm. I personally think that people who are file sharing media material, whether it be music, movies, video games, all whatever. Um, they they're customers in some sense, and HBO, for example, uses those statistics as uh, as statistics to conduct further business and make decisions off of, but not to sue people. Whereas these companies are suing people uh, off of the thinnest evidence because it's really where we start to get to that extortion scheme or scam or copyright trolling or phishing expedition.
I'm kind of curious. I don't know if this would be necessarily something in your purview, but like, if you how do you tie an IP address to a user?
So I argued against this recently in two cases, one
Mm-hmm.
in Eastern Pennsylvania and one in Eastern District Virginia. Um, and the judges that disagreed with me, I'll explain how they would have explained it. That the law of discovery of evidence, the law of discovery of relevant evidence, which is evidence that makes the claims or defenses more likely to be true or less likely to be true, is broad. The discovery is broad. And at an initial stage where a person or entity is making out a prima facie case, the basic elements of a case,
Mm-hmm.
as long as they've met their Federal Rules Civil Procedure pleading burden, which is a well pled case, which means that the defendant can identify what they're being sued for, then the case is able to survive a motion to dismiss and proceed forward. Uh, Other things, totally assuming other things.
Mm-hmm.
And the BitTorrent cases, they claim to see infringement and they argue that they recorded the infringement and they saw the infringement and someone verified the infringement and they have copies of how it was all done and they're prepared to come to court and it's really injuring our industry and we're real copyright plaintiffs and please let us have a subpoena.
Mm-hmm.
And the judges grant a subpoena and say that the plaintiff is allowed to conduct an initial investigation. They are allowed into the initial phases of discovery where they get to depose a subpoena recipient, which could be a subscriber or could be a defendant who has infringed on copyright. But
Okay.
how would the plaintiff know unless they ask? And the great debate is whether they're even allowed to ask.
Well, I'm thinking like even if they ask, like, what's to keep me from saying like every time, like somebody came over to my house and they had a laptop and they connected to my Wi-Fi and they're the ones who
Sure.
downloaded this. Like, how do you ever get over that? Even like even in civil court, that just seems like an impossible thing to get over.
In a legitimate case, it would come down to the facts and circumstances. You
Mm-hmm.
would see the timing of the infringement. Hopefully, a legitimate copyright plaintiff has recorded more than just a single instance of alleged file sharing. So maybe they see that the infringement occurred over a period of 9 months
Okay.
or something. Um, the tenuous claims that we have in the real cases right now seem to stem from what other things you did, like the total picture of what was downloaded. You downloaded things from our adult entertainment company, but did you download things from Disney or from other major motion picture companies or video games or computer applications or something? And then does that correlate with your personal preferences? Do you use that application? Did you watch that movie and like it on Facebook? Did you tweet about how you couldn't buy Adobe Acrobat, so you downloaded it via Pirate Bay or something? They're allowed to conduct that sort of an inquiry, and they're allowed to do it in a litigatory process as opposed to outside court and then have to bring that in. They're allowed to get it after they filed the lawsuit, which means we're now halfway into a lawsuit, which means the defendant has had a very adequate opportunity to sweat this all out and decide to settle the case instead of going through all of this.
Gotcha.
And guess what? The demands will often be very similar to the amount of money that the defense attorney is demanding to defend the case.
Sure. And then just as a final thing, this is always done in a civil manner, right? Or does copyright infringement ever reach like criminal court level?
It's for
Oh,
the creators,
so
right?
what I'm talking about is always done in a civil manner. I have never heard of I think it would have to be the FBI to get involved in criminal copyright in this for copyright infringement of this nature. Criminal copyright infringement is like creating an enterprise out of copying.
Gotcha.
So making copies of DVDs or Blu-rays, or uh, hosting a pirate radio type service that broadcasts video signals to, unpaid, unauthorized video signals or something.
Okay.
And even then, I really haven't heard of anybody being prosecuted for criminal copyright in a very long time.
Yeah, gotcha. Okay.
Maybe it happens behind the scenes and I don't hear about it, but I would think it would make the news once in a while.
So is that initial, I downloaded something with this IP address, how far can you go with just that if there's none of the ancillary facts supporting that type of thing as well? If I didn't tweet on Twitter, man, I wish I could download Avengers, where can I find it? And then I do it 2 minutes later. If it's just my IP address downloading a movie, how far can the copyright holder go with just that timestamp plus an IP address?
It varies. The legal standard is called preponderance of the evidence. It's like a 50-50 or tug of war standard, and it can vary from judge to judge. So one judge may be more convinced by certain kind of evidence than another judge may be convinced. I was trying to convince my local judges here in PA and South in Virginia that the standard for IP address being a person had to be higher than what they were allowing in the court.
Mhm.
Whereas other judges, like Judge Lamberth in DC, threw these companies right out on their butts because he saw through the tenuous claims of infringement and believed that, how do I put this? The claim needs to be stronger on the outside of the case before we get into the case. They need to know more about the infringing activity so that they can identify, if not the name of the person, at least come into court and say, well, we know it's a person who drives a red car and likes the B movie and was at the residence on these dates that these infringements occurred. Maybe something like that, and they'll tell you that they do have that. They just don't plead it in the initial thing. But that's the threshold. Should mom or dad or grandma or somebody who's innocent, who's just a subscriber on the thing, should they have to answer a federal copyright lawsuit because somebody else behind the internet connection allegedly committed copyright infringement?
Well, is there no precedent that's followed across the federal level? Like I
There's
know
no
there's probably
uniform
nothing that is,
precedent. No.
and individual like circuit courts don't have to follow other ones. So like if there was something in the Ninth Circuit that said, okay, to get this far, you have to go to X, other courts don't even have to follow that. It's only Supreme Court or something.
You are watching the birth of a new star here. The copyright. This is the birth of new copyright law. There is no. There's precedent in the sense that there's non-BitTorrent file sharing precedent, and then a whole bunch of Malibu Media and Strike Three Holdings cases of this exact kind. But there's no uniform circuit level or Supreme Court level precedent to control at all. So the individual district courts can vary even between district and even between judge in the same courthouse.
So just to get a couple things straight, like from like a legal point of view, if you were doing a civil case and you've been granted, like you're in the discovery phase, and then you have the ability to subpoena people for information, this is something that you can do kind of like with police backing, or how does that work? Like, let's say I can subpoena like your ISP for like a record of like your IP addresses or something. Do I have to, do I present the subpoena like in conjunction with like a local like police office, or do I just like mail it and say, hey, here's my subpoena, give me this information? Or
the recipient of the subpoena would just be the legal compliance department of the ISP. Most entities, well, actually every entity has to have sort of an official address for receiving service of process or official mail and things like that. So that would be where you would serve them, would be at their official legal compliance address.
Gotcha. And service doesn't have to be done with like a legal professional, or I'm sorry, or like a law enforcement officer or somebody, right? Like you can serve.
No. In fact, there are process servers, and as long as you yourself are not a party to the case, you can serve. I don't know if it's been resolved yet, but there was some question whether an actual attorney in the case can serve the opposing party, what we call original process, basically the first service in the case. Most of the time we use outside process server. I've literally asked a friend of mine to do it. As long as any competent adult over 18 can serve as long as they're not a party in the case.
And
Gotcha.
what is the bar for getting a subpoena? Like, let's say right now me, and I want to subpoena his ISP for all of his emails that may have mentioned my name. What is the bar for me just finding an attorney and say, hey, let's do this, let's send it off?
Well, that bar is what we call Rule 11, Federal Rule Civil Procedure 11, which is the attorney has a responsibility not to send a frivolous subpoena or otherwise maintain a frivolous matter, etc. And yeah, we all know that attorneys can get away with some pretty frivolous stuff before it becomes anything that's going to be sanctioned in a court or whatever. But the practical answer is that the attorney has almost nothing stopping them from sending a subpoena. By being a licensed attorney and being admitted to a federal court, I'm granted the subpoena power, and I can subpoena without any further oversight. And then if you don't like my subpoena and you're the recipient of the subpoena, or even if you're not, you could try to go to court and oppose my subpoena. But I don't have to ask for permission for it ahead of time. There are some cases where they do have to ask for it ahead of time, and those are the cases that I work on, so that's kind of odd. But generally speaking, you don't have to ask for them ahead of time.
Interesting.
Specific. And that's federal level. State courts could be a little bit different. But even at the state court level, you still just go to the state courthouse or the county courthouse, pay your $3.50, get your blank subpoena, fill it out, and send it. You don't actually ask the court for permission. The opposing party doesn't have to answer the subpoena. They're not violating a court order by not answering the subpoena. They might be in violation of the subpoena, and the judge might not like that. But hey, whether or not they're in violation of a court order yet,
Wouldn't you have to compel somebody at some point to follow like a subpoena? Like if you're trying
and that's exactly what you do. You do like a motion to compel.
Gotcha.
If someone is not obeying your subpoena, or a motion for sanctions, motion for contempt or something if they're in contempt of an order.
So hypothetically, in this circumstance we're talking about here, what is the bar for getting a subpoena? Me as a private citizen, again, coming back to like the example here, like if I want to get access to Steve's emails here, what is the bar? Like if I can make a reasonable case to an attorney that I think that something's happened, is that the type of thing? They'd be like, yeah, I think that's reasonable. Let's send it out, and then it's up to him to.
Well, yeah. If we're not talking about, if we're not speaking legally, ethically, if you're just trying to find a way to do it, yeah, you would need to convince an attorney or a court without an attorney that you have some kind of legal claim against him that involves you subpoenaing his emails, or rather requesting his emails via discovery. And
it's kind of shocking because I think myself and a lot of other people assumed, maybe from watching too much Law and Order, that a subpoena meant you were going and having your attorney ask the assistant DA and laying all this evidence on the table, and maybe you're going to get. But it sounds to me like I can just like go find some lawyer at a fucking strip mall and we'll send it out and hope it.
Yeah, and then it's up to the recipient to oppose it. So the subpoena is for someone's information, whether it be producing documents or producing a person to testify. And so if there's a problem with a subpoena, you oppose the subpoena. But yeah, it's reverse of that. You don't have to get permission for the subpoena in most cases. You have to oppose the subpoena if if the subpoena is improper in some way.
When you're litigating this type of stuff, or when you're involved in court for these types of cases, do the judges and jury have like any idea, or I guess I should just say the judges here, do the judges have any idea like what's being discussed, or do you have to bring in like a lot of expert witnesses to explain stuff, or what is like the process for that?
The judge, when I think about presenting something to a judge, I'm assuming that the judge is extremely busy and won't have time to look at my case, and will be very relieved if they can look at my case and understand it quickly. So it's in my best interest to prepare my documents in such a way that the judge understands what's going on as quickly as possible with as little complication as possible. And yeah, for complicated matters, that might mean we need an expert and we need days of testimony or documents to preparing briefs, so that the judge and their clerk and their staff can read them ahead of time. And that's really my goal, is to make sure that the judge has all the tools. I don't assume the judge is dumb, but I assume the judge doesn't want to have to figure everything out for themselves, because they do that every day for everybody. So if I can make that a little bit easier for my judge, I might not win my case just because I made the judge happy with my brief, but the judge is paying attention to my brief because I didn't piss them off with a bad brief
Sure.
or lack of information.
For these types of civil cases, what are like the general types of like maximum damages somebody can actually sue for? Like, say I download like a movie, like Avengers Endgame. Like, how
Yeah.
much am I liable for, like in civil court?
The precedential numbers are around $2,250 per illegal download.
How do they
And
arrive at
that's
that figure?
$750 is the minimum copyright damages under copyright statutory damages.
Mm-hmm.
So we have actual damages and statutory damages. If I ram into the back of your car, the actual damage is your like personal injuries and your damage to the car. However, maybe I ran into the back of your car because I was drinking and driving, and maybe the judge is going to multiply your damages by 3 times and award you extra money. Well, that's not your actual damage. That's some kind of extra damages, maybe punitive damages or something.
Mm-hmm.
Well, copyright doesn't have punitive damages. What we have are liquidated damages, and they call these statutory damages. Liquidated damages would be, I'll use the car scenario, is kind of stupid, but I'll use it since we're using it since I'm on it already. Would be like if everybody had an agreement that if you get rear-ended and there's no major injuries, the damages are $5,000. Doesn't matter whether it's a ding, doesn't matter whether the car is totaled, it's $5,000. But you agreed. Everybody had to sign a piece of paper that said that they knew that if they got into a car accident, they was getting $5,000 and that's it.
So
I
even if
agree.
it's a
This
Lamborghini or like a Focus ST,
right, and this could be incredibly stupid. So just help me with the with that a little bit. That's liquidated damages. This is better in a contract scenario where like you hire me to write a book for you and I don't write the book. So how much are you damaged by? Well, was the book going to make you a millionaire or was the book going to flop? Was it my fault? We don't know. We just know that I didn't finish the book. That part's my fault. So we might agree not afterward, but ahead of time that if I don't finish the book, your damages are $5,000. And so that way we don't have to have a fight over $5,000. So the copyright statutory damages are set at $750 per infringement minimum to $30,000 maximum for most kinds of infringement, and then willful infringement can go all the way up to $150,000 per infringement maximum. And judges have said that this is the minimum kind of copyright infringement, not the maximum. So 750 is the number, but it is a willful act. You clicked on a thing, you downloaded a thing from BitTorrent, and not from BitTorrent, but through a BitTorrent protocol-based file sharing system network, and your damages should be multiplied by 3. So 750 times 3, 2250. Long story, sorry.
Gotcha.
But,
No, that's fine. Have people ever like gotten in trouble for like streaming media? Has that ever been litigated before?
Yes, that's
Not like the content hosters
I'm
themselves,
not
but
up
like
on my jurisprudence current with streaming media, but I remember there are various forms of this. The ones that I'm really curious about are the ones that take a cable television service that you pay for, but then they stream it to you anywhere.
oh, with the little tiny antennas that they were trying to get around. Did you see that? It was a very clever
Yeah,
legal thing they did. That was like called
yeah.
Arrow.
And it
Arrow. I
turns
think?
out you can't do that. Turns out that that's copyright infringement because you're transferring mediums, and that involves the right of publication or distribution. And yes, your TV company, your cable company is allowed to prevent you from rebroadcasting their signal, even if you paid for the signal, the original signal. You might be able to do it privately, but not through somebody else's service. Like they can't do it for you. You maybe they could put equipment on your premises that you can do it yourself, and maybe they show you how and you pay them for it or something. But it has to be, it can't be distributed through their service.
what about like if you so like a lot of people will download movies, but a lot of people also will visit sites where they just watch like streaming movies. Do you think that
Yeah.
like has anything like that ever gotten someone in trouble before, or is that a lot harder to like get people on? Or
That's a little bit harder. The problem or the claim is against the website owner
Yeah.
or host, and a lot of those hosts are not in the U.S. or aren't around long enough to sue, or they can't find a defendant to sue. But yes, I have received some phone calls from people who have actually found certain websites like popcorntime.io that embed at least last I checked, a BitTorrent client
Mm-hmm.
into the web browser through, I guess, JavaScript, and then stream the movie very Netflix style as as user friendly as possible. But it's using the BitTorrent protocol as it's doing that.
Mm-hmm.
And I have gotten calls from clients who think that that's how they were caught
Yeah.
streaming or caught file sharing because they didn't remember streaming anything else
Mm-hmm.
or downloading anything else via Pirate Bay or anything like that.
Yeah.
So one thing I want to ask, as it applies to what we're doing. So right now we are live streaming on Twitch, which
Sure.
is um, something that's become commonplace, and I'm very curious as to how this is going to look in the future. Is a few things. The first thing is, let's say during our hour long or 2 hour long or however long this interview is, that we pull up a YouTube video and we watch it from start to finish in the middle, and we don't
Yeah.
say anything. We just all watch it together.
Yeah.
How does that change the monetization? So let's say that we made $100 during this interview. How much of that is should be property of that YouTube who essentially
Yeah.
was rebroadcast?
That's a very involved question. I almost wanted to say difficult question. It's more just complicated. So the copyright infringement carries remedies that include a disgorgement of profits. So you could be sued, in theory, you could be sued for a complete disgorgement of your profits from that stream. Well, then, how much of that stream and how much of the profit from that stream was from you broadcasting that YouTube video, and how much was not? Well, sort of the copyright infringement argument overcomes there, and it doesn't really matter if you uh, had other things on your stream. The fact that you had this major act of copyright infringement on it was enough to sort of disgorge your profits for the whole thing.
That's very interesting here. So if we had a 6 hour stream, just the act of watching a 30-second YouTube video with no commentary, just me looking at everyone else looking at the same time, is that enough to have nullified the entire period? And now that copyright owner can do I own that video anymore? Do I own
You and
that?
I have hit the exact same point, but on opposite sides. I was thinking of a longer video and a shorter stream, and you were thinking of a longer stream and a shorter video. Yes, the threshold is in there someplace
Mm-hmm.
where a short video and a long stream really shouldn't be an act of copyright infringement. However, copyright infringement is a strict liability offense. It's not an intentional tort or anything like that. It doesn't matter whether you intended to commit copyright infringement, like you intend to commit murder or you intend to commit fraud or something like that. But if you just commit the act of copyright infringement, you're liable for it. And so there should be some damage, in theory, just in theory, from showing really any act of copyright infringement in any length in a stream. And whether they get your whole profits for the stream, that's going to be a bigger argument. The defense attorney is going to, in me, is going to say, well, yeah, longer stream shouldn't be a complete disgorgement of profits. Just hit us with a copyright penalty, statutory damages or whatever, and we'll pay it from there.
So you're saying it could be, well, there's two questions here. Sorry, I'll let Steve ask a question, but you have the mandatory minimums. You're saying this is copyright infringement. I watched a YouTube video. It's not fair use because I didn't commentate. I just watched it from start to finish. It's 30 seconds.
Yeah.
So there's that mandatory minimum. You were saying $750 and it was willful, so maybe $22.50. But the other thing is that compounded because I've rebroadcasted this to 1,000 users or 10,000?
So that would normally compound it, and the amount would be higher. But then I skipped something. In order to have statutory damages, you have to properly register your copyright. I was going to say 99.9% of YouTubers do not register their copyright.
Wait a second. Is it? You don't have to register a copyright to file a DMCA, right? Are you just talking about just to acquire damages?
Correct.
Okay.
You do not have to register a copyright to file a DMCA or otherwise own a valid copyright, but you do have to register a copyright in order to take advantage of lawsuits of the legal system in that sense. In order to file a lawsuit, in order to make a claim in a court. We recently had the case of Fourth Estate versus wall-street.com, and they said that you have to file for a copyright registration, and you have to have the approved copyright registration in hand before you are allowed to sue.
Can this be done like
Very
retroactively?
limited circumstances. You can register retroactively, but you won't retroactively get statutory damages, only for new acts of copyright infringement.
Oh, hold on, wait. This is very interesting to me. So what you're saying is that theoretically, okay, so I'm guessing that these sorts of registrations are probably on a public like registrar somewhere or something, right?
Yes, you can go search these registrations.
So if I were to ever get not that I would ever do this or suggest anybody do this, but if I were to ever get a DMCA from any streamer ever saying, hey, you're using my content, like I'm DMCAing you so you can remove it, I could theoretically try to find that in a register somewhere. And if they haven't actually registered their copyright, I can essentially tell them to fuck off because they have they can't take me to court. Like I could basically do a counterclaim and they could never take me to court for it since they don't have it registered and can't retroactively.
Your counterclaim might, well, see, they still have the right to have the material taken down.
Mm-hmm.
And you are daring them to take you to court by making them file a counter notification or by denying their counter notification.
Mm-hmm.
And the problem then is that yes, if you have found that they do not have a copyright registration, then you know they can't sue you for at least 6 months, or however long the Copyright Office is taking to grant registrations at that time, which is right now around 6 months.
Mm-hmm. Well, and you said when you said that, or go ahead.
I recently registered something myself, and it took about 4 or 5 months to get my registration in the mail.
But even if they registered it, you said they can't like retroactively sue you for that previously.
For the actual damages, yes, but for the statutory damages, that one's still a little unclear because the Supreme Court in Fourth Estate changed the law on the application requirement. Does that mean that you can retroactively sue after you knew about the infringement and you wanted to sue and you maybe contacted them and tried to work it out or something? You're waiting for your application to go through. They know that you have an application pending. When does that become statutory damages? Is it the moment that the registration is granted? Is it the moment that you receive it in the mail?
Mm-hmm.
Yeah.
Interesting.
So that's up in the air, I think, right now. Maybe another lawyer has a better answer than me, but I feel like that's up in the air right now.
On kind of like a broader question, and I don't know anything about like legal history. So a general question, though more specific, is it normal for like new areas of technology to figure out what you can or cannot do? Is it more normal that like court cases and like case law and like legal precedents will kind of like carve out how that is litigated? Or is it more common that like sweeping legislation from Congress will figure out how that's litigated? That's like my general question.
All I think of is Uber. Are you talking about Uber?
Well, now I'm talking about the copyright stuff because it feels like for the internet copyright stuff, like a lot of this is still up in the air. And then my more specific question is, do you think it's good that a lot of this is being decided in the courts rather than getting some like comprehensive like legislation from Congress to figure out what should or shouldn't be allowed?
Do you trust Congress or do you trust the courts? Now that I'm an attorney and that I've seen many courts, I trust the courts a little more than I trust the Congress.
You don't think it's hurtful that a lot of the litigants like bringing these suits forward though are going to be like powered by like really expensive corporations that might be trying to like push on their behalf?
That is a problem that we discuss on the channel regularly and that I confront every day. How can I represent my clients, and how can I also help people on the channel who there's this huge disparity, like you just said, between major media corporations and individual YouTubers or content creators.
Mm-hmm.
And when they get a false claim or when they get an illegitimate copyright lawsuit or something, there's almost nothing for them to do besides roll over and do whatever the claimant wants them to do, even pay money, because they don't have any other choice. The disparity is so great, and some judges are very sympathetic to that, and other judges don't see it as a problem they can solve, so they're not going to try.
If you can you ruin it for like everybody else if you either settle or lose a case like that? Like, let's say for instance, like, okay, so like if 100 people settle, somebody can't come to you and be like, yo, everybody settles this, like this is bullshit.
Sure. I'll tell you my story. This is the one that I've had on my chest for a while. One of the very first BitTorrent cases, there were 5 defendants, and my client really, really wanted to defend his case, and we really, really wanted to win, but they they made a settlement offer, and he accepted the settlement offer, and it involved him admitting that he, in fact, was the liable party.
Mm-hmm.
Now I know that I didn't do anything wrong. That was the best way out of the case for him.
Yeah.
But did that do a disservice to future cases? Sort of. It wasn't what I would call precedential in the legal sense, but
Mm-hmm.
it definitely persuaded that judge and other judges that the plaintiff wasn't entirely illegitimate, and the maybe the concerns that their claims were even illegal, even dishonest and illegal, those claims maybe are a little bit exaggerated. And because look, they caught somebody here, and believe it or not, the five defendants in that case, all five of them settled in one way or another throughout the thing. So that was really kind of a 5 out of 5 for that company. And yeah, that influenced future cases. Definitely, future judges paused for a moment and said, "Well, I would normally throw this out,
Mm-hmm.
but you did get 5 out of 5 on that one. Hard for me to say that you got admissions of guilt. It's hard for me to say that you didn't have something there." So judges have been persuaded to give them a chance.
Isn't that like, oh man, okay, I have two more questions. I'm sorry, then Dan can go. Okay. Okay. Isn't that like really not a good interpretation of like the legal system? I thought settlements were like explicitly not supposed to be looked at as like admissions of guilt, or like, or is this just something
This
that
was an
happens regardless?
explicit. This was included in the settlement. Was my client will sign a piece of paper, and that piece
Oh,
of paper will be presented to the judge that says, I am the liable party in this.
Yeah, that's an
okay, okay.
Alford plea, you idiot, Stephen. How can you know
Oh,
that?
my bad. Okay, so this includes some admission of guilt. It's not just, well, they dropped the case and they settled out of court or something like that, right?
Yeah, we did settle out of court in that particular case, and most of the BitTorrent based ones that I do settle out of court.
Okay.
It is a strategy to settle in court on what's called an offer of judgment, but once again, we have to get our clients to want to go into court, even just one step into court, and many clients don't even want to set foot near the idea of a legal process, let
Hmm.
alone pay a lawyer and file a thing and have their name and livelihood attached to it on some level.
Gotcha. And then so kind of my final question in that same vein, like can you literally ruin it forever with case law if you get like a bad lawyer? Like let's say for instance, I'm sure you follow it. I don't know if you commented on it, but like the React stuff was getting like a lot of heat on YouTube,
Mm.
especially related to like H3H and
Oh
whatnot.
yeah.
Let's say
Well, it
you go
depends on the law.
Yeah, let's say
Sorry,
that
go
you go
ahead.
to defend like a case and you get like the shittiest lawyer imaginable and he's real bad and a whole bunch of other people are telling you like, dude, like don't fucking do this, you're going to mess it up for everybody. Your bad lawyer goes to court, you go to court, you lose the case. Are other lawyers going to look at that as like case laws, like legal precedents? We're like, well, this was tried before, I'm dismissing your case because this has already been taken to court, even if your last lawyer was really shitty. Like
Well, it
does
has to go to the Supreme Court, right? You're saying like a shitty lawyer to the Supreme Court?
Well, no. I'm just saying for like normal, like for normal cases that people might like use to like build like case law or something. I
Well,
don't
if
know how
you're
that.
Yeah.
listening earlier, he said that inter-country cases don't really set case law to that level.
Well, so there's a couple ways I could see this.
Mm-hmm.
So in general copyright law, no, not really. The cases. Let me come back to that.
Mm-hmm.
I'm thinking more like you mentioned with trademark law.
Sure.
If you have like the Fine brothers trying to trademark the word React for reaction videos,
Mm-hmm.
yes, they could potentially get a trademark on that. And if nobody opposes them, and if the trademark examining attorney grants it, and I guess if nobody opposes them for 5 years, and there's a few other things, but as long as nobody opposes them, basically they could have the trademark and own it forever. And this is how we have Susan G. Komen having a trademark on For the Cure.
Okay.
Any charity that goes out there and uses fun run race for the cure, not and it's not Michael Scott in a fictitious activity, is could and does often find themselves subject to litigation or a threat from Susan G. Komen.
Okay.
I personally don't appreciate that as as an attorney, but hey, they're allowed to defend their trademark, and if they don't, they lose it. So that's how trademarks work.
Interesting.
There's also a fun one called adverse possession, which is just a fun term to mention for your audience who might be lawyers or law students. There's this fun, and I'm saying fun sarcastically, uh, operation of laws. It is not, there is no law called adverse possession, but there is an operation of law where there's a statute of limitations on, say, property and stealing someone's property. Well, what happens if they have that property? What happens if that property is like real estate, like land or a abandoned building or
Like
something?
squatters, right?
Squatters, but you don't care. You know that they're there, and enough time goes by, you could lose your right to sue them and evict them from the property. And we just lost my feed. There we go. Okay.
Okay.
So there's a law of adverse possession, more complicated than I'm even more complicated than I'm making it sound. But if someone basically squatted on your property or otherwise, and you knew about it, enough time went by, you could no longer sue them to get them off the property. Well, guess what? They can now go to court and say, well, their lawsuit rights have been extinguished. I effectively own the property, so I should now officially own the property, and the squatter can actually get the property.
Mm-hmm.
That's why you get
So
the
that's
squatter
not
stuff.
precedential, but that's where if like you didn't have proper representation, you could lose your rights. Now, fortunately, adverse possession is usually 21 years. So this has to be going on for an entire lifetime, basically, like an entire generational gap, like 21 years. So not a thing that happens frequently, but it can. In
So
copyright law, oh, go ahead.
No. You go ahead and finish your thing, please.
In copyright law, could an incompetent attorney or could someone represent in a poor enough way that we got some terrible precedent? Yeah, it could happen. I like to think that copyright is an intellectual enough pursuit and something that judges don't come across often enough that they end up having to fully research it for themselves when they see it. So I'm thinking the judge would at least overcome the worst of the incompetency from a bad attorney or bad case or something. But that's just a hope, and we do have cases like Citizens United where we might disagree on whether unlimited campaign contributions are a good thing or not.
So what I wanted to ask you, again, coming back to the Twitch thing, and the new forms of entertainment that we're having here, something that's incredibly popular, and I don't know if you've ever experienced this before, is watching a movie with someone else.
Yeah.
It's better than watching it by yourself. You're talking amongst yourselves, things like that. So the natural progression of that is to watch movies with lots of people, essentially. So let's use an example of like Game of Thrones right now. What is the and this is kind of a two-part question. The first one is what do you think the path is if we wanted to like stream an episode of Game of Thrones on Twitch? Where does the bar between fair use and copyright infringement go? Right? Because if we were to stop it every minute and say, do you see how let's say I'm an artist and I want to talk about all the lighting and things along those lines and all that type of stuff. At what point is it legal for me to do this? Do I have to miss entire elements of the show? Do I have to stop every certain period? Do I have to be changing it? So what's your view? Where would you feel comfortable streaming an entire episode of Game of Thrones? Let me ask that.
The big question is a fairly deep dive called market usurpation, which is just one of the four fair use factors. The four fair use factors are a balancing test. You have to consider all of them, and you can't just throw out a case because you've got this one factor. But I would say in that scenario, the biggest factor, I'm going to call this the MST3K scenario. But let's all remember that MST3K had permission from KTLA to produce their show.
Just for the audience, MST3K is Mystery Science Theater 3000, the guys that would like watch a movie and then kind of like have the little silhouettes that would like laugh at the movie as they're watching along, right? Yeah.
Right.
Hey, but do they have permission from every show that they watched? I mean, I understand if they're okay, gotcha.
And it's because of this factor. It's the market usurpation factor. It's phrased as market usurpation because it's not just market overlap, but rather, is someone going to be able to watch your production and not have to go watch? Is your production going to be an effective substitute? Effective substitute. People are actually going to do this. Is it going to be an effective substitute for the original work? So if somebody watches your take on Game of Thrones, so I just watched Alt-Shift-X's episode 4, take on episode 4 of season 8. Is that he shows a lot of clips of Game of Thrones, and very likely without permission. It might not even be a fair use because some of those clips are just filler. They're just B-roll. They're not related to what he's saying on the screen sometimes. And so it could be copyright infringement and not a fair use. But
So
What if somebody
what
like
about
what if in one
is
of these
someone
clips?
going to watch his video and then know everything they need to know about that episode and not go watch that episode? And is
what
that going
about
to be a
with live
general
political
practice?
like, so for instance, when we were having the debates with the Democratic candidates,
Okay.
many Twitch streamers were putting them up there and just watching it live, like through like Fox News or CNN
Okay.
or whatever that was. Is that the type of thing? And this wasn't C-SPAN, which I don't even
So
know
it's
if you can
political
rebroadcast.
discourse, right? But it's not C-SPAN.
Exactly. So if you're like rebroadcasting live Fox News debates, is that like, and you're in the corner and maybe pausing and saying, "Wow, Bernie is so fucking stupid. He's never going to get elected. Biden forever, etc."
The second fair use factor does take into account the nature of the work. So I would say that political discourse, even if it's being rebroadcast from some other source, like if you're rebroadcasting Fox News, but you're making political commentary on it at the same time, or any commentary whatsoever on it at the same time, that sounds much closer to a fair use. But honestly, I don't. That's a really good one. I would need to do some really deep research to figure out whether streaming someone else's political debate, because Fox News has every right to make money off of streaming.
And they might have
private.
exclusive rights and everything like that to the debate, right?
Absolutely. But we also have the right of fair use and definitely the right to even the responsibility to have a discourse about it. So I definitely see courts carving a giant exception for that. Much
currently, as
fair use on that, but less of a fair use for Game of Thrones and more towards fair use.
Well, that's our assumption, right? Like, or because the biggest problem I think there is with copyright laws, it's just unknown. We assume that should be the case, but has there ever been legislation or anything saying like, okay, political stuff, that's more fine than Game of Thrones, right? That's what just we're assuming should be the case, correct?
Yeah. And then there's the third fair use factor, which says you're only supposed to use as much as you need and no more. So in your political discourse idea, could you have simply given people a link to the Fox News live stream and then you could have held a chat on a different web page or something? Would that have worked just as well? A court would then say, if you didn't do that, you were supposed to do that, and that would be a violation of that fair use factor.
And then just for stuff related to this, because people argue about copyright stuff on the internet all the time, fair use is always something that has to be argued in court, right? There are no like hard and fast guidelines, like where it's like, oh, well, this is obviously fair use, so like that's my defense, and I don't even have to go to court.
Correct.
Right? This is
I have developed a feel for fair use over 8 years of being a lawyer and 3+ years of making a YouTube channel that deals with copyright law. And I still have to pause and do a fair use analysis for each and every individual case. So whenever somebody says, well, what's the easy rule? I have to take a deep breath and try to explain as calmly and patiently as possible that there is no shortcut for that particular rule.
Yeah.
You can develop sort of some feel for it, how you're using it, and there's sort of a practical side to it that's not part of fair use, but I always ask myself, is the plaintiff really going to sue?
Yeah.
If I go and use my friend's photo from his vacation, I don't have permission, but he's not going to sue me. Like, but how about if I go and use Getty Images? Yeah, they're going to sue me. So, and then there's a whole spectrum in between.
And then like, there's never in the history of like all of like fair use case law, no one has ever been saved by putting like that disclaimer in their description, right? Like it's literally
or in your Facebook comment.
I would argue the opposite. I would say that by putting that there, an attorney, a prosecuting attorney, a plaintiff's attorney could argue you knew about fair use and you still didn't do the right analysis. So that negates your defense of, I thought it was a fair use.
Okay, yeah, I gotcha.
I'd like to ask about another thing. So I don't know if you actually watch Game of Thrones or nothing, but
I do.
Lately, there was a lot of leaks that came out with the new episodes, and HBO was very protective of this type of stuff, right? So you saw, like, basically, it was either insiders or people had access to the script, or, we're not entirely sure, but, the endings for Game of Thrones were leaked to the internet. And HBO took a very aggressive, I believe, from what I read, aggressive response to that, trying to basically remove that. Now, do you think that spoilers and that content should be copyright protected, and should and more importantly, the people that are like kind of taking that copyrighted content and redistributing, so like putting spoilers out there, should they be held to damages as well, like compounded damages?
So the law itself obviously is not written spoilers are such and such or whatever. So instead, what we have to do is apply copyright law to the spoiler and decide whether it's a violation of copyright. Copyright law does protect the right of publication, distribution, public performance, that sort of thing. And so I don't see any reason why HBO wouldn't have 100% interest in eliminating spoilers off of the internet. It's also the heart of the work. So whether Jon Snow lives or dies this episode or whatever is part of the heart of it. We're all watching for that one moment, not necessarily watching a horse across the screen or something, in a generic B-roll footage or whatever.
Do you think we're going to get to the point where people are suing people on the internet for spoiling them?
I mean,
I've already seen takedown notices for it. Yeah,
absolutely.
Wait, for just for text, but for actual clips.
I don't remember what the scenario was, whether it was text or whatever. But so the idea itself is not copyrightable. Mm-hmm. So writing the words in this episode, Jon Snow dies again. Sorry, spoiler.
Whoa! There's litigation right there. All right.
There's litigation. I don't know that the idea itself is copyrightable. However, the idea is not a fact in this case. It's fiction. This is somebody's fictional work.
Well, yeah, but it's also
if you actually knew that whether or not somebody lived or died, and then you're saying that, and you're not bound by a confidentiality agreement, is that copyright infringement? I'm having a difficult time seeing it as actual copyright infringement, but it's definitely headed there.
Maybe we can at least agree that these people are like real assholes, right? The spoiler people are like real assholes. We can at least agree.
I don't think this.
Right?
Yeah, that I agree with.
I agree with you.
My girlfriend and I literally had this conversation. She's overseas, so she wants me to wait until the next morning, and I'm like, but I have to then avoid the internet for an entire evening, basically.
Well, wait, would you do that? You would avoid social media for a day or two to not get spoiled? Do you think that's realistic?
I did that once and then decided not to do it again. Yes.
Okay,
yeah,
that's awesome.
It's really,
literally like 2 weeks ago for episode 2.
It's really inconvenient that you'd have to do it, and I think that like really.
Dan, can we move on topics? I'm sorry, my community is okay. We're good. My community is
the poor people the most.
Very divided on this right now. This is a hotly contested topic.
Do it right away.
Apparently, you were brought in here to arbitrate this conversation for us. Okay, moving back into the more serious copyright issues. Do you have a strong stance on oh god, is it Article 13, the European new
Article 13, 15, 17, whatever it's called now?
Yeah, whatever article it's become. Yeah, do you have a strong stance on those copyright protections that were being proposed for the European Union?
I'm just myself coming up to speed on how law in the European Union even works, and my understanding is that this is a directive that then still has to be implemented at the state level. Each individual country has to implement their version of the directive within the directive's guidelines. And so the directive says, no filters, but here do all of these things that tech companies would normally use filters for. I'm really on the fence. That could go either way. I'm very concerned that the requirement could be filters, even though we're not going to say the word explicitly.
And what do you mean when you say filters?
Oh, so the directive requires content hosts like YouTube or Imager or really any content, any user-generated content site to police itself and obtain proper licenses for any copyrighted material that appears on its site. Now, this is actually towards your Game of Thrones example. So if you wanted a site where everybody could go and watch Game of Thrones episode, the latest episode that's streaming right now, and it's still legal, that would be this, where a site would be allowed to do that, but would have to obtain the licenses to support that. And then what's the other half of that? Well, what happens if Game of Thrones or HBO doesn't want to license that live stream because they want you to come pay for their streaming service? but you've got user-generated content on your site. So when are you crossing the line there? So we're still waiting to see when how that gets implemented. But basically, the content host would be responsible for the copyright infringement if they were unable to police it off the site or get a license for it. And so if they streamed Game of Thrones and they didn't have a license for it, then they would also be guilty of copyright infringement, not just the user who uploaded it. Right now, the user who uploaded it is the only party responsible as long as the content host is following the law, which we call safe harbor.
Mm-hmm. So one of the big concerns that people had was that as far as I understand it, as long as you make a good faith effort to take down copyright infringing material as a content host or content provider in the United States, you're not going to be directly liable for users uploading copyright infringing material on your platform. I think one of the big worries that a lot of people had was that this new European directive would basically unlock the ability for countries or companies or whatever to directly sue content providers themselves, and that there would be no safe harbors for them hosting content infringing or copyright infringing content. Do you think this is like well founded? Do you think this could be a potential thing, or do you think these fears are overblown and this won't actually happen? Or
well, so the only thing that stops me from saying that that's a possibility is my brain going, that'd be stupid.
Well, it would effectively shut
frankly,
down like every.
And then, frankly, that's not stopped things before. Like stupid stuff has happened.
If this were to happen, it would effectively.
My gut reaction is that this really could be implemented in a truly anti-content creator or anti-content host way. Because someone really thinks there's all this copyright infringement out there and they're just ready to go get all this money, not realizing that YouTube doesn't make as much money as they think it does, and Google doesn't. Well, Google does make a lot of money, but Google isn't going to be able to support itself in its current form if, say, it has to go in and pay for every bit of content that it summarizes or thumbnailizes or aggregates.
Well, the idea, I think, behind a lot of this is that I don't want to say the small content creators, but the big boys out there were tired of the fact that people were uploading shit constantly. And it's like, it's this never-ending game of whack-a-mole where there's no money at the end of this type of thing. So the thing is, fuck it. Let's make Google and YouTube. They have lots of money. So we can go and sue them when they do it. And maybe now they'll get off their lazy asses and actually keep our content from being off their thing. But the thing is, it's ridiculous because, as we've known, it's just type of filter list that would have to be made to stop this is near impossible. It's going to stop free speech. It's going to stop things like if it applies to images.
Yeah, this is user engagement. Let's remember user engagement is important to spreading the word and making our brands popular.
But correct me if I'm wrong, but my understanding is that it's been approved, but it hasn't gone as law yet, and it could still be repealed or not put into practice.
I don't know the status of the final European Council's vote, which is the heads of state. Assuming that they voted it yes, which I think they would have by now, but I'm also not sure. That was only a month or so ago, was the last time we checked in on that. Then yes, it heads to the member states, and each individual member state will write their own version of that law. The actual law itself doesn't tell the member state, arrest a person when they do this. It says, define a crime of this and a penalty for when a person should be arrested for it. And then they go and write the crime. They go and write the version of the crime that applies to the person. In this case, the copyright law is going to have to be written from the new law is going to be written from scratch in each individual member country. Now, that doesn't mean that they don't talk about it or that someone won't try to circulate a uniform code or model rules or something and try to get everybody on a uniform law. That would be normal. That would be helpful if we all knew what the law was and it wasn't different in each individual member state. But the member states are also allowed to be individual and different, sort of like the states in the United States are allowed to be a little bit different.
One thing in regards to this that I wanted to bring up, which is very confusing, but I think you probably know more about this. So in regards to DMCA, on YouTube specifically, there's this two-pronged standard, and I seem like Google is using it in two different ways, is that they have their own internal system that copyright holders can use to remove content. But I assume also you can also send a legitimate DMCA to YouTube. So I remember reading some sort of case where someone was suing someone or someone was getting sued in regard to this, and they said, you never sent a DMCA. And they're like, well, yeah, we did. We did through YouTube. Like, oh, no, that's just a copyright takedown. That's nothing legal.
I don't
So
think there's a difference between these, right?
no, I believe there is a difference, but you can say,
We've definitely heard this before, and the short version is that yes, YouTube's internal process does follow the DMCA's requirements.
Hmm.
So, I don't know where the misconception came from, but every time I've gone anywhere near that takedown form, it always says the DMCA takedown form or takedown notice
but is that
form.
an actual valid DMCA that you
Yeah.
are submitting when you use that term? It is.
Yeah, it's a valid DMCA takedown notice and should hold up in a court of law and should be a date for when we send a takedown notice for later reference in court.
I think the DMCA takedown forms, it's kind of like, you can tell me if I'm totally off on this, but it feels kind of like a cease and desist, where like some people think that there's like an official like government form DMCA dash whatever that you have to fill out for DMCA, but as long as it hits like the main points of like this
Yeah.
is copyright infringing material, it needs to be removed, like that's a valid DMCA takedown. There's not like an
Yeah.
official government form for it.
Well, I mean, my understanding was that when you did a DMCA, that you were supposed to look up in the copyright database the proper DMCA agent, and then you're supposed to take your data and send it to, you take your form, and you have all the, I swear under penalty of perjury that all these things are true, and here's my signature, and here's my address,
Yeah,
and that you're
that's
supposed
one.
to send it, and that you're, there's the whole list, but you're supposed to send it to the designated copyright agent, and that's
Yeah.
why I was wondering if that.
Yeah, as long as you meet those requirements, it's a DMCA, whether no matter what you call it.
Mm-hmm.
Sure.
As long as it has the identification of you and that you're the copyright owner and the specific links to the material, the offending material, and the perjury line, like you said, and as long as it goes to the either registered agent or legal compliance officer, yeah, they have to comply with that and follow
So
that if they want to
no,
remain
no,
in their safe harbor. They
sure.
they
So there's
aren't
no
actually
point in
legally
doing
compelled.
a normal DMCA then.
Yeah, they aren't actually legally compelled to obey the DMCA law or obey the DMCA takedown. They're compelled persuasively by the safe harbor provision. If they want the safe harbor, then they have to follow the law to stay in the safe harbor, which is why they sort of so coldly observe that.
Mm-hmm.
Except, of course, now we found out that some music copyright plaintiffs have indemnified, or at least I think they've indemnified YouTube, and YouTube is no longer observing the counter notice procedure for those plaintiffs. So if you get a strike because you uploaded, say, a fair use of a song, well, YouTube is not going to grant your counter notice and put the song back up. The song is staying down, or the song is staying monetized with another claimant, and you have to go to court after that person. And you can actually now sue YouTube for that because YouTube has broken out of its safe harbor. And I think the only way that YouTube would break out of its safe harbor is if it was being indemnified by one of the music plaintiffs, like UMG or
Can you explain what you mean by that when you
Sony.
say indemnified? Like, what do you?
So the DMCA safe harbor protects YouTube from liability. If I,
Mm-hmm.
let's say I upload a copy of $100 bills
Mm-hmm.
because I heard it from the Beat Saber story from Jimmy Fallon the other week, and but I made fair use of it. Let's just assume for the moment that I made fair use and that we're not disputing the fair use part. I made a fair use of it. I made commentary, and I only used as much as I needed. I didn't usurp the market, etc.
Mm-hmm.
I make a fair use of it, and I've lost my train of thought. Damn it.
And you get the DMCA takedown notice from them, and you can't do the
Right.
count.
And I get and I can't do a counter notification, and so I can now sue the plaintiff for the misrepresentation. They didn't consider my fair use correctly, and I can sue YouTube because YouTube denied my counter notification in violation of the safe harbor provision. And I can try to receive actual damages, including attorney's fees and costs and everything from both of them.
Interesting. Okay.
Oh, and the
Again,
indemnify provision. Normally, YouTube wouldn't open themselves up to that kind of lawsuit. So I'm thinking the plaintiff would have to say, YouTube, if you get a lawsuit over this, we'll pay for it. We expect so few lawsuits over this, we're not worried about the money, we'll pay for it.
Mm-hmm.
So they have I'm guessing, again, speculating, that the music copyright plaintiffs have a written agreement with YouTube that the copyright plaintiffs will pay for YouTube's expenses if they get sued under those circumstances.
Okay. As we're getting a little late into it, I wanted to wrap up kind of with some thoughts on specifically, you have your own business
Yep.
doing copyright law, and we've run into a few of those topics I think that we definitely want to cover because we're very interested in a lot of these legal things. As you know, we've watched a lot of your streams before, and we've gone over this type of stuff.
And
But
these are like these copyright things are always like hot button issues too. Like
exactly.
people are always
Yeah.
like trying to DMCA each other. Like I've been involved in shit like that, like on the receiving and giving end. So like yeah, there's like a lot of these conversations like pop up a ton in these types of communities. Yeah.
Yeah, it's really nice that you're able to kind of clarify to a certain extent what is and isn't okay, so that we can kind of. I mean, not this is not legal advice for anyone out there.
Sure.
But,
No, we're having
you know,
a conversation. It's okay.
So yeah, the thing I want to ask is, you created a law firm. How do you want to speak anything to that after you take over? Your the failing law firm. How is the business, the startup doing this? What are your goals? Are we going to see you with 50 associate attorneys next time this year as you continue to be the internet's most well-known attorney, or what?
Oh, thank you. I don't know that I'm growing that fast. We've suffered 5 YouTube adpocalypses, and because I'm doing this legal education thing, we get lumped in with some of the more extreme YouTube channels occasionally, and we'll get demonetized because someone, I guess YouTube, thinks that we're a conspiracy theorist channel or something like that. So we overcome those. Recently, we've started paying our editor and paying my assistant, which is a nice thing to have, so that we can have someone produce videos for us even when I can't get around to the editing, and we have somebody managing the business behind the scenes. So as far as the startup is concerned, from there, the first BitTorrent-based copyright infringement cases started coming through, and since I was involved with the first trial, I pretty much just leaned on that and started getting clients by the dozens, as these plaintiffs began filing these lawsuits by the dozens. And they come in waves. Sometimes there's more or less. I think the plaintiffs actually schedule these things around different parts of the year. So there'll be fewer of them at Christmas time and fewer of them during the summer and vacation time and all that. But other times of the year, there's a whole bunch of lawsuits, hundreds to thousands of lawsuits per year over this BitTorrent-based file sharing copyright infringement. From there, I began advertising. I used Google AdWords for advertising, used various pieces of software to manage the practice. Been a solo attorney for the entire time, and only hired an assistant last August. I probably didn't know what I needed an assistant to do until I had several years of practice under my belt. Now that I know what I need to do, I've been able to give all of my repetitive tasks to my assistant, and I pretty much every day just find a series of draft emails in my email inbox, waiting for my approval, editing, and then sending. And I get to do the high-level work of tackling legal advice issues, talking to new clients, and deciding overall strategy in cases and things like that.
Do you imagine yourself hiring additional attorneys and things like that, and kind of growing to be like the preeminent kind of copyright firm? Or?
I'm not sure. So then the YouTube channel happened. The Fine brothers went to Trademark React, and I made a video about that. I think I was wearing a beanie and maybe even a bathrobe, and I talked about how ridiculous it was, and somehow that got hundreds of thousands of views. And that was my first major experience with making any money on YouTube, and that got my attention. And I then went on to talk about some of the other lawsuits that made the channel famous. Some of that was pretty much luck. I showed up. I was one of the first people to show up. I was one of the first people to show up who was willing to talk about YouTube stuff. How many other lawyers were focusing on the community, the YouTube community? So I think that helped a lot. And now we have a half a dozen or more attorneys who are regularly making content on all this stuff, which is really cool. I don't want to say that I led the thing, but whatever part I had in it, I'm very proud of, because this is a really cool thing that we've got going on now. When I went to law school, they told you not to be involved with social media and not to post a picture of yourself on Facebook, because heaven forbid it could be misinterpreted by a future client. I found the opposite to be true. I found not having a social media profile meant that anybody could take it over just by typing your name once. So rather, if you have your Twitter account and you have your Facebook and you have all this under control and you're handling it properly, nobody's really going to be able to go write one thing. I mean, sure, a big story and all that, but I mean, it's more so like one idiot writing something isn't going to suddenly blow up your entire social media profile and end your job or your career. Likewise, having clients as a solo attorney, I'm not going to lose all my clients at one time. So there's some diversity of income there. And then the YouTube channel has now been growing. The first year we tried to hit 10,000, then we tried to hit 25,000, then we tried to hit 50. We blew past 75 and then hung at like 86,000 for a while. And then last year we hit 106. And now I think it can go a lot farther. So where do I envision myself? I'd really like to see both things grow. I'd like to see us have an even greater YouTube presence, and then also have people in the background who can be helping the YouTubers and content creators that need help. There's a lot of trouble with this. Triaging cases, everybody's fair use case is different. It takes a long time to go through one fair use problem, and there's thousands of them per day, and no one wants to pay for it. What am I going to do? Start collecting donations for people to pay for other people's maybe fair use problem, maybe just total misinterpretation of the law?
On this, do you have like an opinion on I'm trying to remember I don't remember if you commented publicly on this or not, but didn't somebody try to solve that, H3H and the video game attorney guy, with their, was it like the FUPA fund, like the fair use protection something, where they tried to pull a bunch of money for content creators?
Yes, and I don't know that it survived very long. I honestly really don't know any of the details of its demise.
Wait, that died?
I don't know if it died. I haven't heard
okay.
about anything about it lately. Yeah, I really haven't been that's been about a year. Yeah, about a year or so ago was the last time I heard anything about that. I thought that the fund had served its purpose and was quietly closed, but I could be wrong. I don't mean to miss.
Oh, okay. I thought the goal of that
there.
fund was like kind of like what you're saying. Like it was supposed to be like a big pool fund
Yes.
for a bunch of content
And my
creators.
assumption was that it had closed because it's more complicated than it initially seems.
Yeah.
So we're still trying to figure. Every day I think about, okay, how can I run a, like you said, public benefit corporation that will be able to help these YouTubers, but yet also not be the least effective thing I've done in my life.
Yeah.
I could just end up answering basically a bunch of tech support phone calls about fair use that could have been better handled by somebody watching a video or otherwise reading something on their own. Where what I really want are those edge cases where we need to make new law and make it clear to judges where that line is between fair use or not, or free speech or not, or religious freedom or not, etc.
Okay. Are there, or I'm just kind of curious, just because you're here, are there any like internet legal things that like drive you crazy, like things that people get wrong over and over and over again that you find yourself talking about a lot? I mean, I'm sure there are. What are some of these?
Well, fair use.
Yeah.
The sovereign citizen movement is a very impressive movement. There's a lot of things going on there. I've even had a sovereign citizen client myself from that family law practice a long time ago, and that's just remarkable that they basically get it wrong, but it's like the business is getting it wrong. They're almost intentionally not caring about the details of the law, hoping that the complex language and sort of pain in the ass nature of sovereign citizens, that the judge and court just won't want to deal with them.
Mm-hmm.
There is no such thing as this, like to dispel this right now, correct?
There's no real thing. There's no such thing as an actual sovereign citizen, as in a citizen who themselves has an equal level of sovereignty or authority as the state. That does not exist. There are people who don't think that they've consented to live in our society and don't think that by consenting to live in our society, they have to obey our laws. And I get that. I don't remember signing anything that's, I consent to be born. Mom and Dad, I've been fully informed about how horrible or not the world is, and I consent to be born. No one can do that, right? So we're all here against our will in some sense. And I guess some people really, really feel like it's against their will, and they want to try and equalize the playing field, and they get it somehow through their heads. Sometimes it's a scam, sometimes it's a delusion. They get it through their heads that the court doesn't have authority. They might not understand the complexity of the court system, where they might have been fed misinformation, but these people really do believe that they have that the court system has no actual authority over them. And there's usually often a great deal of cracks in this.
Mm-hmm.
Oftentimes, sovereign citizens will be the first to call the police or something like that, appealing to the same authority they say doesn't, have authority over them. But, that's just part of the idiocy or lunacy of it.
Do you, I'm kind of curious because this is something that gets memed about a lot. Is it actually like advisable, or do people win like a decent amount of the time, like fighting traffic tickets by just going to court and hoping that either the cop doesn't show up or they wrote their name down incorrectly on a traffic ticket? Is this something that you would recommend that everybody do if they have the time, or is this generally just going to be laughed out of court, or what?
It's both. I've been both, and I've worked 3 counties. So here in Lehigh County, Pennsylvania, not that it terribly matters, but just so you can tell the difference. In Lehigh County, I can make deals out the wazoo. I would often have my client pay me a flat fee, and I would promise them they don't even need to show up to court, and I'll just go and I'll plea it down to like the lowest charge, whatever their 10, 15 miles an hour over the speed limit is. Worse than that, no, you're probably not going to get that good of a deal. And if it's a really, really low charge, occasionally the cop will like plea it down to a non-moving violation or something. However, one county over in Northampton County, they don't negotiate at all. And one county down in Berks County, they hadn't heard of this. And they had to look up whether I was even allowed to represent a client, and the client is not present. And I had to get out the book and explain to the judge, Judge, I know, like, this is new, but it's not new.
Sure.
Well, there's at least down here in Florida, there's entire industries that are built on this, and I've used them. I have an idea of how they work from talking with them. Essentially, if you get a speeding ticket, you hire this firm, like the Ticket Titan or Ticket Clinic, things along those lines. You send them the information. And the way that they get, like, I think close to 99% dismissal rate is they go to court, and if the cop's there, or if there's no errors on the ticket, they see if the cop's there. If he's not, then they win. If the cop is there, they ask to reschedule. And then on the second time, if the cop's there again, they ask to reschedule. And that's literally the entire business of how they do this.
Yeah, that's one effective way to do it.
And it just seems so stupid, but it works, I guess. I don't know.
Debtor-creditor law works like that. A lot of times the creditor has to have an original assignment of the debt, and a lot of times they have a copy. And so I had a person I dated, a lawyer that I dated once, would take these cases en masse, just basically take anybody's case. That didn't matter the facts. They would just show up to court and see if they had the original documents. And a few other things. And if they didn't have the original documents, then they could object and the whole case would get thrown out and that person's credit card debt was gone. And they would charge like $250 for this. So that was a real good service.
Oh, that sounds clients. Like, how do I do that? That sounds fucking good.
Well, you have to not pay your credit cards, let your credit score tank, let your credit rating tank, and then eventually get sued. And then you can make them not pay. So it's really, you're already in a bad situation if you've gotten that far.
That sounds less exciting when you put it.
Yeah, it isn't quite that easy.
Yeah.
But if you're already there, $250 could get you out of that debt.
All right. Well, listen, Leonard, it was fantastic having you come on today and talk law and copyright and everything else. And I hope that our audience has learned something, especially those who are aiming to become an attorney. And it was fantastic having you here. And I hope, how can our viewers find you if they want to watch more of your?
The show is Lawful Masses, LAWFUL, Lawful Masses, with Leonard French on YouTube. We also own lawfulmasses.com, and let's see, is there any place else that no, pretty much YouTube. We have a Sunday show. We do a live production every Sunday morning from 10 to 12 Eastern on twitch.tv/lawfulmasses, which we then produce into videos for the week on YouTube.
Oh, outstanding.
So
cool.
our audience has a couple different ways to engage.
Do you guys have a Patreon as well, right? Or am I making that up?
Yeah, patreon.com/LJFrench, and we're trying to spread the word about Sponsus, my developer. I'm not financially involved other than being like a Patreon creator.
Mm-hmm.
I'm a creator on Sponsus, but I don't have a financial stake in Sponsus.org. But it's a Patreon competitor. Sponsus.org/u/lawful masses. We'll get you to our page there. It's almost identical to Patreon, but it was created in response to some of the Patreon discrimination. The word, I don't mean it in like a
What do you mean by
super bad way.
discrimination?
Yeah, wait, who was kicked off of Patreon?
Uh-oh.
Like,
Oh,
So
no.
hold on,
back,
you have to
well,
go for a little bit more here.
first of all, December 2017, Patreon decided to change the way they charged people's initial charge their monthly donations,
Mhm.
and people who had been donating like $1 a month found that processing fees were charged to the dollar a month, rather than like if they had 15 patrons that they supported for $1 a month each, they would get charged the processing fees on each $1 charge, as opposed to one processing fee on a $15 charge.
Mm-hmm.
Well, at 2.9%, who cares? Well, there's a 30-cent fee on each one, so you're getting 30 cents out of each $1 transaction instead of 30 cents out of one $15 transaction.
Wait a minute, that seems completely reasonable because that's what Patreon is probably getting charged to do that. That's
Well,
a
is
standard.
Patreon collecting just 15?
Patreon
or-
was charging them in the aggregate, so
Yeah.
we should be getting charged in the aggregate, and they switched it specifically to be not charged in the aggregate, and they didn't talk to any of the creators or the patrons. And so that was what initially sparked it. And then, even though I don't always agree with people's politics, I don't agree that people should be kicked off of Patreon simply for having a political message that I disagree with. And there were several people. I know Sargon was one of them, but I don't want to personally be associated with Sargon. I'm just saying that was one of them. And then we had a bunch of complaints from many people in our community are familiar with the adult entertainment industry. I really don't know exactly why, but I have no problem with it. I'm familiar with the industry myself.
Mhm.
When I used to go on dates, because I have a girlfriend now, when I used to go on dates, I would often tell on the first date, my opening line after somebody would say, "Oh, what do you do for a living?" And I would say I'd work in the adult entertainment industry, because I defend people who are sued by the adult entertainment industry. So, I'm like 2 degrees from them.
Tangential
And
to it,
and,
yeah.
and then I would gauge how much of a good time I'm going to have with this date, depending upon whether they're horrified or whether they think that's funny.
Mm-hmm.
So,
Okay.
where were we?
You were talking about people you were upset kicked off of Patreon.
Oh, right. So Responses was created to be more equitable or equality based, so that anyone who could at least meet the minimum standards for their payments to be processed at all wouldn't meet any further discrimination from the platform. I know that's a really weird way to say it, but even Stripe, which is Sponsus's service, has limitations on who can be a payment collector.
Wait, I just realized. I'm sorry, I have to do it. I just realized we haven't talked anything about the political climate right now and all the legal shenanigans that are going on. And I and I have a lawyer here.
I'm very good at avoiding it.
Yeah. Okay.
Wait,
man,
political stuff
see,
related to what?
to all the legal insanity that's going on right now.
Well, he
with
has
Trump and all
copyright
that
law. I don't know if he
Yeah,
cares
well,
about can Trump be
he's-
held for
I-
obstruction
I
of justice?
care, but I'm not necessarily more well versed than
Yeah.
anyone else.
Okay, well, listen. Let's give us one hot take on anyone. You can start on Michael Cohen, on Trump.
Oh no, I was a Bernie supporter, and I even did poll watching for Bernie.
That's
And,
okay. You're still a good guy. Yeah, you're in
Yeah.
Pennsylvania. It's okay.
And I ended up voting for Hillary because I couldn't see myself voting for Trump. But what I'm seeing with the political climate is my major concern is the violation of the checks and balances between the branches. Even if a person supports the current presidential administration, I still think the current presidential administration is going outside of its authority and should not be opposed to checks and balances from the judicial and legislative branches. At least my whole life, I've always seen Congress and the judiciary putting limits on a president's authority. And the president seems to be making not just an opposition of it, but seems to be making it kind of a theme to their campaign, is that they're opposed to any oversight.
Yeah.
And on some level, it's true that the executive branch does not have there's no oversight over the executive branch for executive designated functions, those things designated by the Constitution. But then there's two other articles in the Constitution that designate what the other branches of government do and how they oversee the president, and how the president puts a check on congressional action, and how the judiciary puts a check on legislative action and executive action. And we're seeing an unraveling of this right now, or at least a major challenge to this right now. And so I'm firmly on the side of Trump is doing things well outside of his power and needs to be, if not impeached, at least investigated, and then impeaching needs to be on the table if the investigation shows. And then we have part of an investigation, and the investigation seems to show something, but then there's a lot of hiding of the investigation. Why would there be this hiding of the investigation? I understand that everybody has a due process right, but we're not talking about an individual citizen in a criminal charge. We're talking about the administrator of the country that was purportedly elected. So I just have some questions and some problems with the I would use the words constitutional crisis we find ourselves in today.
So it sounds like you don't think he should be able to declare a national emergency one day and then the next day say we're keeping it, but there is no emergency. So
right, that there should be, things should not just the letter of the law, but the spirit of the law.
Yeah.
I'm not saying that every president I've ever supported has always acted within the spirit of the law. I supported Obama, and Obama had his flaws. I had some problems with Obama too, but the political climate, even though it was still changing, I thought it was pretty bad during Obama. It was not as bad as it is today. The divisiveness, the separation, the parties not talking to each other, even private individuals, you and I've noticed that people don't talk to each other about politics anymore. This conversation here is the most that I've talked to us. I don't mean to call you strangers, but the most that I've talked to a stranger about politics in this entire political administration.
No, it's very crazy right now. Like, I mean, I'm definitely not a Trump guy, but like, even if I was, I would not wear a Trump hat outside. A "Make America Great Again" hat, you go the wrong place. That's like, it's basically the equivalent of having like a swastika.
Oh, yeah. Well, that I would be concerned about too. There are crazy liberals just as much as there are crazy conservatives. We need to talk about the problems not as in, and I'm not accusing anyone here. I'm just saying in general. When you talk about the problems as in people have problems and need solutions, not, well, do the Democrats deserve to be better favored, or do the Republicans deserve to be better favored? No, it should be more so about how do we best serve the citizens of the country, and that's what I'm not seeing here.
Somewhere in the middle.
Yeah, mayors of cities do a better job governing their cities than Trump is doing governing this country, in my humble opinion.
Yep. All right, just wanted to dive into that quickly. Listen, it was great having you here today. We'll have you back again in the future sometime. This is very exciting, and thanks for stopping by.
Yeah, definitely fun. I can talk your ear off about copyright law, as you may have discovered. So,
I'll get some additional questions, and depending on how the spoiler law goes, we may be in touch for some representation.
Yeah, that's a good one. I think we might try to write a story for that. See what the law of spoilers is.
If you're looking for someone to litigate against who was involved with the spoilers, message me after the show, and I can
get out of here. All right, thanks a lot for coming on, Leonard. We really appreciate it.
You're welcome.
Bye.
Thanks.
Yep. Thanks a lot for joining us, guys. Have a good one.